everybody. Happy Labor Day. Good day to do a full-on live stream. AMA, Ask Me Anything, entertainment law session. Thought I would just drop in and hang out here, see if anybody has any entertainment law questions that they'd like to get answered. And I'll see if I have any burning questions that I get in email from time to time that I haven't already done an answer to. But let me see if this is positioned about right. Okay, that's pretty good. Should be getting pretty good audio level from that. Oh, that's the wrong mic that I have selected here. Hold on. I'll switch over to the other mic here. And I can get this one out of the way. Don't need that for today. So, Labor Day. Here we are. Let me move my confidence monitor over here so I don't have to be looking off to the side the whole time. So, welcome. Today is the first day of September. The third of 2025 has just come to its end. We're starting the home stretch toward the end of the year. And thought I'd just come on in here and answer some questions. So let me see what I've got. Questions, let's see. Okay, well, here's a question from my friend Nancy. What do you need to do to work with an original IP that is past copyright or out of copyright? Are there still legal requirements and licensing or similar to be done? Well, that's an interesting question. Out of copyright or past copyright means that at least for copyright purposes, the work has fallen into the public domain. And that means that there is no obligation to get permission or license the content from the original author or copyright holder because the work is no longer covered or protected under copyright. But does that mean that you're free and clear to use anything you want anytime, anyhow? Not necessarily. We still need to think about if the material is about real people, then we need to think about defamation and privacy concerns. And if it's a commercial project and, like an ad or a promotional thing, and you're going to use that material and it's about a real person or names real people, then you may have some concerns about what we call the right of publicity. That's the right of a person to control the commercial use of their name, image, and likeness. And so that's something to be thinking about. And another point is, the defamation, a false statement about a person that causes an injury to their reputation. Doesn't matter how long ago that statement was first published. If the person is still alive, well, then we have a defamation action. Libel would be the case. So that's something to be concerned about. Unless the person is a public figure, and then it's less of it's not a completely absent concern, but it's less of a concern. For works of fiction, generally speaking, you're okay to go forward. There have been a few wrinkles in this in recent years dealing with properties that were created in serial form, and some of the works have fallen in the public domain while some have not. A best example is the Sherlock Holmes character was originally created, quite some time ago, and then and it was originally in serial form. It was coming out in a magazine or publication of some sort, and each new story would come out, and then the new books would come out, and that would further develop the character. And so the estate of Arthur Conan Doyle did sue successfully in a couple of instances when character traits that weren't evident in the earliest stories but were developed later in the series, but in works that were still covered by copyright, made their way into newer projects. And so that's the kind of thing we do just need to think about. But really, it's just a matter of doing some analysis and thinking through these things and figuring out what is it you're using, where did it come from, and are we sure it has fallen into the public domain? But generally speaking, no. If a work is not protected under copyright anymore because it is the copyright has expired or been abandoned, or dedicated to the public domain, then there's no other licensing to be worried about there. In the music arena, this becomes an issue because a musical composition that was written 500 years ago could theoretically be re-recorded by a new orchestra or band or something today, and the band would own a copyright in its recording of that work. But the composition is free for anybody else to make new recordings of or perform publicly. So if you want to use an older musical composition, we need to verify where the source, what you're using as the source material for that. Certainly, if you've got sheet music, you can get an orchestra to record it for you, and that's perfectly legitimate. But if you're using that newer recording, then you may still have to obtain what we call master use licenses to incorporate that material into a film or a television show or a podcast or something like that. Now, other questions. Let's see. First of all, if you're here joining me and you'd like to just say hello in the chat, let me know so I can say hello back to you. Love to know who's with us today. And it looks like I've got somebody watching on YouTube, which is great. So yeah, drop a note in the comments and let's chat. If you have a question, of course, ask away. That's what we're here for. It is an ask and answered session. Ask me anything, preferably related to my field of expertise, but I'll try to answer other questions too, I suppose. I do my own hair, in case anybody's wondering. Another question that I got also from Nancy: how much danger is there really from giving your logline to someone at a cocktail party? Is it good enough to say, please don't steal my idea? The problem is, no. When you offer up the material, your ideas, your logline, whatever it is, without some kind of a clear, demonstrable understanding that there's a transaction to be had, that it's there's a quid pro quo expected. You know, if I give you this and you like it, you're going to hire me to write the screenplay. Or if I give you this and you like it, you're going to involve me in the process. Hi, Felina. No, you're not. I started right at 10 o'clock, but I've just been, jamming, chit-chatting. But yeah, if you've got questions, you run a rock band in Vegas. Licensing is huge. Okay, let's talk about that in a minute. Let me finish this question and then I'll get to yours, Felina. How much danger is there from giving your logline? Well, the issue is, unless you have that transaction, an understanding that there's a transaction, it's going to look like a gift in the eyes of the law. And so unsolicited pitches and things like that are similarly risky for both the recipient and the donor of the pitch, the giver of the pitch, I should say. So be careful. The problem with cocktail party is you might be talking to producer A, who's standing in front of you listening intently, and maybe even has said, yeah, if I like it, I'll definitely pay you or buy it from you, whatever. But standing right behind you, overhearing it, might be producer B, who doesn't have any contractual or implicit contractual understanding with you. And so it is dangerous and risky to share those kinds of things in a public forum where it might be overheard, because once an idea is out there, it's free as the air, as a famous judge once said. So be thoughtful and careful about when and how you share material. If you meet somebody at a cocktail party and you tell them you've got a great idea and you'd love to share it with them, make an appointment to see them in private and keep track and records of that appointment. Follow it up with an email. Maybe it'll even feel a little excessive about documenting the process and the situation so that you have some evidence that there was this understanding. When you send things over by email, words like sending this to you in confidence, or even more explicitly, I'd like to have a conversation about selling you this idea and screenplay, this pitch. Are you interested? And then they say yes, then you send it over. Something like that. That way you have a clear understanding of there being a need for a transaction, that kind of thing. So, Felina, I hope I'm saying your name correctly. Rock band in Vegas, licensing is a huge pain point for us. Thank you for the super chat, Felina. I appreciate that. Is DistroKid sufficient for releasing cover songs? You know, I don't know much about how DistroKid operates, but I think so. Thank you for that. I think so. Cover recordings in particular, there is an obligation to pay the publishers of the original songs for the mechanical licenses. That's what mechanical licenses really are. You don't need any permission to do it, but you do need to pay the statutory mechanical rate unless you negotiate a better deal with those publishers. And it is often possible to negotiate a better deal. It's not unusual to see a deal for 75% of the statutory rate, for example, so you save a little money that way. I don't believe DistroKid handles that payment for you. So that may be something you need to clear to do by yourself. I am not a music law specialist, and I don't do much work with recording artists, so very hard for me to answer this completely, without any reservation. So this is something you're going to want to check on. But I would start by asking DistroKid, hey, do you pay the mechanicals or do we? I think they, actually, now that I think about it, they must do mechanical license payments unless they require you to pay a certain flat rate up front. But mechanical licensing is usually done through an outfit called the Harry Fox Agency, which is a sort of a division or related to the National Music Publishers Association. And you have to, I think you pay them sort of a flat rate per 1,000 units you're manufacturing or something. The problem is nowadays we're doing streaming and we're doing digital downloads and things like that. So it's getting harder to track for the average small band, but it is not insurmountable. There are certainly good resources out there. And Felina, if you need to be pointed in the right direction for those a little further, let me know and I can give you some names and contact info. There are good people in Vegas who can help you as well. And there's that. So thank you for a great question. Appreciate it. So if you're just joining the call, I see we've got a few other ones. We've had a couple of other people join in, but anyway, they lightly mentioned covers are fine, but I'd love to make sure we're legit. I've heard of Harry Fox. It seems so complicated. Yeah, music copyright is very complicated because there's, lots of different copyright owners and things like that. DistroKid should be able to answer that question for you. If they say that covers are fine, presumably that means that they're deducting from what they pay you on those distributions to cover those royalties. And the mechanical royalty rate, the statutory rate for royalties, is, I believe, 10.1 cents per unit sold. So when you do, and I don't know how they do it for streams, but DistroKid wouldn't be about streaming anyway. That would be something that would be dealt with through, I think, SoundExchange for digital downloads and streams. Digital streams, I should say. Anyway, there you go. All right, on to another question. If you're just joining us and you have a question about entertainment law stuff, please do ask. I'd love to help you find an answer. Thank you, Felina. Here's another question from someone who wrote in to me. He says, in a script I've written, a side character's actions are based on a real life member of the community's wire fraud scheme. I found the story in a news article on a major website news platform, and the person's name, gender, location, and other surrounding details are different in my story. But the fictional character does have the same job role and committed the crime in a similar manner. Am I legally obligated to buy rights to this? And what am I legally obligated to do? Well, obviously, I can't give a formal opinion or reliable legal opinion here. You need to check in with a lawyer who's been hired to help you with that if you're concerned about this. But based on this little bit of information and generally speaking, facts of a crime are public. At least by the time there's been a trial, they're public. Usually they've been reported in the news, they've reported in the media, and there are things like police records or public records. So that can be reported by anybody out there. Excuse me. The concern might be that if this person is recognizable to people who know of him or her in your script, and then there are other aspects of the portrayal that are false and harmful to the reputation, even though that's hard for someone who's been convicted of a crime to prove, then they might have a claim for defamation. So an example of that might be a person is convicted of a minor financial crime or drunk driving or something like that, that, can sort of happen to a lot of people. But the story also portrays the person. Let me get the focus back. Where'd the focus go? There we go. If it also portrays the person as a perpetrator of a much more heinous crime, a murder or a rape or a child molestation or something like that, well, then they could claim that you've tarnished their reputation beyond where it was damaged from the factual stuff. And again, if it's false information, that can be harmful and defamatory. So the thing about it is, for screenwriters, you have to think about this, but it's really the job of the producer who takes on the job of making the film to do that due diligence, to do that legal clearance work and make sure that there aren't any problems. So if you are transparent about the facts of where you got this idea and that there is this actual person out there with a similar fact scenario, at least partial fact scenario, then it's probably, it's incumbent on the producer to do that legwork. I mean, you can, there's a chance you won't be able to sell the script, but we're going to have a visit from Luke the cat. Do you have something to say? Oh, this is Luna. Sorry, I mistook who I was talking to. Anyway, she's just coming in to see what's going on. I've been keeping the office door closed most of the time lately, and so the animals haven't been really able to come in and visit with us. So she's heading over to check out what's on the printer. Okay. Anyway, so when you're negotiating your contracts to sell your screenplay or something like that, you want to be really thoughtful and careful about disclosing those kinds of facts about the source material for story, and be sure that you are not signing warranties and representations that it doesn't depict a real person or those kinds of things. And again, you want to be including that sort of disclosure right there in the contracts if you can. So hope that helps. Other questions? Let's see. What have I got? Well, hello, Certain Exposures. I've forgotten your first name. I apologize, but thank you for that. It's actually Labor Day, not Memorial Day. But Memorial Day is at the beginning of summer, and Labor Day is at the end of summer for those of us in the U.S. And so that's how we remember it. Don't wear white after Labor Day is what they say. So I am looking for other questions. Let's see. What have I got here? Let's see. Yeah. All right. There it is. Labor Day. Yes, indeed. Thank you, sir. What else have we got here? Let's see. Questions about entertainment law stuff that might be interesting here. Excuse me. Let's see. What else have I got here? Let's see. Are there any restrictions on using pseudonyms for your work as an author? Any restrictions or limitations? Well, so this is a question from someone who wants to keep anonymity because of their full-time profession. Curious about the use of multiple pseudonyms. For example, I write westerns and hard-boiled detective novels, and I feel I can use the same name for those, but I also write fantasy and sci-fi and a children's book based on bedtime stories I tell my daughter. I'm currently in the final drafts of 3 different books, which I intend to submit to editors soon. What can I do legally? And the wife actually suggested using a woman's name for the children's book. Do I have any advice? Can you just call me? Okay, I'm not going to answer. I'm not going to even name who this is from, but there's nothing wrong with using a pen name, even multiple pen names. That's fine. But it can make marketing a little bit more challenging. And there have been lots of writers who write cross-genre, and I've even seen somewhere years later, after one of their book series has become famous, their publisher has insisted, let's be candid about who this person is, so that they'll buy the other books from the other genres. So that might be something to think about, is you're building a personal brand of your name for as an author, and maybe it makes better sense to stick with the same name and just be a cross-genre author. I'm thinking of I can't remember his name off the top of my head, but there's a fellow who writes great mystery and procedural stories, but also writes kids stories. And I don't know why my camera keeps changing focus on me, but maybe I need to get a little brighter here. Anyway, I'll get back in focus. I haven't had this happen in a long, long time on the system here. All right, there we go. Interesting. I haven't turned on the background. Alexa, turn on the background lights. That's better. All right. Movie Maniacs MM is asking. Well, let me finish this one, and then I'll get to you, MM. So the only area where writing under a pseudonym can be a challenge is when you're registering your copyrights. There is a checkbox and a special field that needs to be completed for that. And that does make your real identity a bit of a public record, because people who want to and could search the copyrights could find out. And they could search for your name as an author. And I think the pseudonym stays on there. So let me see what just popped up on my screen. I got a super chat, Certain Exposure. Thank you so much. Appreciate that. I'm grateful. So I'm going to get to you, Certain Exposures, but let me answer. Well, I'll, since you gave a super chat, I'll answer yours first, and then Movie Maniacs, you're next. So I have two questions. I do street photography and have a hard time determining if a location is public at some times, like portraits taken in an alley with multiple storefronts on both sides. Any tips? Well, I think that's easier than you might be thinking. And go ahead and drop the second question, and I'll get to it. The question of whether a space is public really is it openly accessible to the public? If it's marked private property, then of course it's not. If it is a place where you have to pay an admission price, then it's maybe considered a private property. Or if it's a place like a sports stadium or something like that, it's a semi-public state, and it's okay, again, to take photographs there. At least if you're not using it for commercial purposes, right? So there are some weird wrinkles in the space where, you're in a public space in an alley where there's a big mural painted on a wall. And the mural artist might have a complaint if you're using that as your backdrop. There have been a number of cases against car manufacturers when a mural is featured prominently in an ad for a car that is, on a public street, and that's a commercial use, and that becomes a copyright issue. But generally speaking, it's a public place. You're allowed to be there. You're allowed to make photographs there, and you're allowed to photograph people who are also there without the need for consent, again, until and unless your use becomes a commercial use, that is associated with a sale or a transaction of some sort. That's when you have to really think about that. So go out and enjoy shooting in places that are, if it's accessible to you without having to climb over a fence or break through a window or a door or something like that, it's a public place. And again, inside a building, probably not, but there are places like malls and shopping centers that are also open to the public, and unless there's signs posted saying that you can't take photographs or those kinds of things, then you should be good to go. Obviously, use your judgment and try not to make people angry. But street photography, if you're on a public street or the alleys between the buildings are considered public thoroughfares, I think. So again, unless it's fenced off and locked up, you should be okay. Storefronts on both sides. Again, you can feature the storefront. I mean, if you get a bokeh effect and it's just out of focus, that's beautiful. But if you want to feature the signage or the front of the store in the images, and again, it's not commercial, you're not running an ad, then you are generally not going to have a problem of trademark or brand confusion or anything like that. If you have if you're conveying a commercial message, then it's a different story, and we need to be careful about that. So, hope that answers that question for you. And you said you have a second question, so I'll look for that. But right now, I'm going to answer Movie Maniacs. Can I talk about AI and copyright for screenplay generation? Yes, I'm happy to do that. So there's a handful of issues that come up in the arena of AI right now. First off, I'm going to work backwards. The output of your AI prompts is not likely to be protected by copyright unless you have done some very extensive prompting and really kept meticulous records of all of those prompts and how you shaped the material. Screenplay content is a little harder than with artwork, where you're telling it, no, change that to a different shade of yellow and make that narrower and that white. The more of that you're doing, that's original authorship, creative work that you are participating in the process. But the copyright law is very well established nowadays that works that are not created by humans are not entitled to copyright protection. So you wouldn't be able to claim ownership of an output even if you're the one who made the prompt, any more than the guy who put the camera out for the monkeys to take a selfie with would be able to claim ownership of those images, or the artist who handed the paintbrush to the elephant that then painted the canvas would not be able to claim ownership of the artwork on the canvas. So those are, the machine is a tool. It is not an author in and of itself. So what it writes for you is not really entitled to copyright protection. There's a bit of a challenging area because the machines are getting so good that it's hard to tell whether something came from a machine or not. And also, we're using these tools the way we've used Photoshop. I don't think any photographer is going to argue that Photoshop is the author of a work that they've made. They're using the tool. So documenting how you use the tool to create the work is important if you want to claim some protection. The case of Zarya versus the Dawn, which was an illustrated novel, a graphic novel, the text materials in the novel were entitled to protection, but the artworks were not, because it was machine generated, and the artist who created it had written the actual text from their own original memory and original conception, I guess you could say. Next issue, though, is that if you are using AI in your research process, in your development process to create the material, you need to be careful, because it's possible that, well, first of all, we're waiting to find out from courts a bit more about whether or not the way the AI machines are trained constitutes fair use. Under copyright law, fair use is a defense that basically concludes it's not infringing, even though they're making they slurped up millions and millions of books, for example. Well, those book authors are suing, and actually there was just a big settlement in the case of Anthropic, Bartz versus Anthropic, I think is the name of the case. They settled because the Anthropic, the defendant, the makers of Claude, didn't want to be subject to a court judgment that could have, been into the billions, hundreds of billions of dollars over the 7 million books that it ingested without permission or without purchasing the books. So that's an issue there, is that your use of the AI could be, following on to that kind of infringement. And the next part of it is the real challenge, is that you have to fact check everything you get out of these machines. The AI, they do hallucinate, they make stuff up, and they also do sometimes output verbatim copy of what they ingested. And even if you don't ask them to do that, it can happen. And so if you ask it to create a character that does, has 3 parameters, and it then generates Luke Skywalker, even though it comes up with a different name, it's the same character, right? So that's the kind of thing you have to really be thoughtful about, because you could be on the hook for what the AI gave you if you include that material in your work. So do your due diligence on that. Fact checking to make sure that if you're using it to do research, make sure that it's getting it correct. Because again, if you're doing, say, a documentary and you're using AI to help you find out some facts about the person or something, there have been cases where the system mistakes one person for another. Maybe they have very similar names, and one person was a convicted criminal and the other one is a politician in another part of the country. If you get that wrong, you could be in the crosshairs for a lawsuit, and saying, "Oh, I relied on AI," isn't going to cut it as a defense. So those are some of the kinds of concerns that we have to think about when using AI for screenplay generation. There's a possibility that the inputs are infringements. There's a possibility that the outputs can be infringement. And there's the absolute certainty that the outputs are, well, I shouldn't say absolute certainty. There's a likelihood that the outputs are not going to be considered entitled to copyright protection. Certain exposure is another super chat. Thank you, very generous. Louis Rossmans asked us to change our profile pictures to Clippy, Microsoft's old assistant, to show support for his campaign against the abuse of data mining by large corporations. Is that possibly copyright infringement? That's a great question, something I haven't thought about, and something I will consider making as a video. Thank you for suggesting that. I will get into that. The Clippy character certainly is something that Microsoft probably can claim copyright ownership for. And I don't think they care, is really what it comes down to. And using a copyrighted image for your profile picture isn't the kind of thing that a copyright owner needs to go after people for. It's a little bit of a making a mountain out of a copyright molehill, essentially. And the courts don't look kindly on that. What are they going to do? Sue 1 million people for adopting Clippy as their profile picture, especially when it's associated with a sort of a political nonprofit kind of a cause. And that brings me to the question of maybe it's considered fair use because it's political expressive speech used to make a criticism or commentary of some sort. Hard to say how that would shake out if it went to court, but nobody's going to do that. Nobody's going to go to court over that. It's just a small potatoes kind of a situation. So technically, yeah, it might be copyright infringement. Does that mean you shouldn't adopt it? And if you believe in the cause, I don't think that's a concern we need to give too much weight to. But that's great. Yeah. And thank you for asking those great questions. Appreciate it. All right. Jake from Windy City. Another super chat. Thank you, guys. I really do appreciate it. It's nice to have lunch money. Can I clarify on what can be done regarding public domain works like Steamboat Willie? Free to remake, but Mickey still owns the Mickey IP. Disney still owns the Mickey IPs, right? Great question. Not exactly right. So the character of Mickey Mouse was originally created in the movie Steamboat Willie, which was released more than 96 years ago now. And that means that character has fallen into the public domain. And so if somebody wants to create a Steamboat Willie version of Mickey Mouse in a new story or put it on a t-shirt or something like that, under copyright law, they are free to do so. However, as I was saying earlier, characters sometimes develop over time. And if you look at the way Steamboat Willie was drawn, and you look at the way Mickey Mouse has been drawn in the intervening 95, 96 years, you can see that it has developed and evolved. And so there are original components of the Mickey character that were not part of the Steamboat Willie. So if you incorporate those newer elements, you could still be accused of infringing copyrights. That's part one of that discussion. So Disney does not own the Steamboat Willie character anymore because it is a public domain character. This is for copyright purposes. However, in case you hadn't noticed, all of the Disney animated films for the last decade or more have included the Steamboat Willie, a clip from Steamboat Willie, as part of the graphical logo that they include at the beginning of the film. That is a trademark use of that character and that clip. And so there's an argument that anyone who uses that version of Steamboat Willie could still be infringing that trademark if they're using it in a trademark way and suggesting that they have some ownership or affiliation with the Disney Corporation somehow. So putting that character on a t-shirt might still be trademark infringement, especially given that Disney puts the character on t-shirts as well. So Disney has been very smart about this. They have very good lawyers in the Disney offices over there. I know a few of them, and they're really on top of protecting this intellectual property, which is, after all, their core business. So be very careful about using the Mickey IP. Other IP that have been similar, I mentioned earlier, I was talking about the Sherlock Holmes character, the way it was written in the early books, evolved into what was written in the newer books. I believe all of those books are now in the public domain, but for a while there, this was a challenge. Winnie the Pooh fell into the public domain as well, because nobody had ever claimed trademark rights to the Winnie the Pooh character. But Mickey is a special circumstance. Mickey is the logo for the Disney Corporation. Walt's signature is one logo they use, and the Mickey character is another logo that they use. And it's registered as a trademark in a number of different classes and things. So this is an area you really want to be careful. If you're planning on making Mickey merchandise or doing a Mickey thing, you're going to want to consult with a lawyer who can give you the straight poop on that. So anyway, I appreciate the great questions that I'm getting here. I really do. If you have another question, drop it in there, Jake. Yeah. Lewis's video was change your profile to Clippy. I'm sorry. Yeah. Is it Louis? What else? The Clippy movement is not just against data mining. It's against other things too, like making software unavailable after purchase, changing terms. Yeah. I've heard about the Clippy movement. It hasn't gotten as much traffic or traction as I would think it might, but it's early days yet, so we'll see about that. Let me look at some other questions that I've gotten over email. Should I form an LLC for my short film? Yeah, you should probably, unless it's really micro budget and you're doing it all really fast and dirty. Having an LLC, I recommend it before you shoot. If you've already shot the film, transferring it into an LLC isn't going to do much to protect you, and so don't bother. That was that particular question that I got from someone named Jeff. So Kathy asked me, I'm confused by the care we take to be certain that when we create a film script, we take care to get life rights and ensure that we get permissions to use a person's likeness and not have anything identifiable about a person if they have not given permission. Recently came across a situation where someone had decided to write a book about all the people in his life that he blames for his addictions and life of crime. And in some cases, he has lightly veiled the people in his book, but they are still recognizable. And in some cases, he has used their real names. Several real people that do not want to be in the book and have sent cease and desist letters. Is there anything else that they can do to stop him using them in his book, as it could be defamatory and if it's made into a movie? Doesn't this break chain of title? So it's not a chain of title question. Chain of title belongs to, starts with when you set pen to paper, you create a copyright, you own that work. Chain of title is the paper trail from ownership of that initial work to transfers to the company that's making the film and or to whoever's doing the next iteration of things, all the way into the distribution chain. That's not a problem, but it does cause a clearance problem. We call that a legal clearance issue. If the script or the story named or the book names real people, it better be true about them. Truth is a defense to defamation claims, and if it's false, then it harms their reputation, then that's going to create some liability. So changing their names may not be enough. If they are still recognizable, then the mere obfuscation of the name is not enough to protect you against that. If you create composite characters, but they still look like a particular person, that can sometimes be troublesome as well. Is there anything you can do to stop it before it gets made as a film? Well, you could sue over the book, and that would certainly tie up it's similar to the chain of title, because when you sell a book to a filmmaker or a screenplay, when you sell it, you have to warrant and represent that there are no claims outstanding that might jeopardize the ability to make the film. So having that lawsuit going and possibly decided can be a factor. But lawsuits are very expensive and very time consuming. And if the person doesn't have much money because they have a jailhouse memoir or something like that, and they just got out, it may not be worth it to bring that suit. Could you wait until the film comes out? Well, if you knew that the book had this false information and you didn't put a stop to it, depends on how much time has passed. But there are principles in the law, statutes of limitations, and another principle called equitable estoppel or laches that might also prevent a lawsuit from being made years later, right? You could certainly sue the filmmakers when they release their film, but again, that's not prevention. That's seeking a remedy for the harm that's caused. So, yeah, that's the thing. One thing I will say, though, is if it's not defamatory, if it's just using their name and telling the truth about them, no, there's not much that can be done. There's actually no such thing as life rights. Life rights is a concept that we in the entertainment law world have used to make reference to what's sort of a bundle of contractual terms that we want to get in place when we're making a film about a real person or whatever, so that we have some more freedom to do things in a more creative way. Our clients have more creativity. Those things that we're buying in a life rights deal are the right to portray the person and to embellish the story, maybe even to fictionalize the story, maybe even in a way that's harmful to their reputation. We want access to them and their stuff. They may have photographs, they may have stories, diaries, all those kinds of things that might be valuable in helping to craft the film. Also, their cooperation in helping you get the film made, but also helping you get in contact with the family and friends that also might be involved and make sure those portrayals are accurate, or that you get rights from them. And ultimately, it's a promise not to sue you, even if the film is harmful to their reputation or misses the point or something like that. So that's what life rights deals really are. Oh, and also exclusivity. You're promising not to cooperate with anybody else during a time window while they're making this film, so that they don't end up having 3 competing films out at the same time, as happened a few decades ago with a very prominent news story that each of the 3 people involved in the story told their story, and there were 3 TV movies based on it. It's the Amy Fisher Long Island Lolita story. She sold her rights. The wife of the victim that she shot, allegedly shot, is also sold her rights, and the husband of the victim with whom the Lolita was having an affair, also sold his rights. And so we saw all 3 major television networks carrying the TV movie within just a few weeks of each other. It was very peculiar. Very peculiar. So, yeah. So anyway, I think I've answered that question. Let me get back over here to Jake. Another question. How has public domain law changed over time? What is the time frame now? Thank you for the live Q&A. Jake, thank you. And thank you for another super chat. And I appreciate the great question. Public domain is really the result of when copyright law runs out, when the copyright protection expires. And so the law of public domain, once it's in the public domain, it's free. It's anybody in public can use it. And that's the meaning of what that term means. Just because something happens in a public place does not make it public domain necessarily, although we were talking about taking photographs in public places. Generally speaking, what happens in public, we're free to photograph and report on those kinds of things. But public domain in the copyright context really means there's no longer any copyright protection. So how has this evolved and changed over time? Well, let me explain. Under the earliest copyright law in the United States, I believe the duration of a copyright and the protection that was afforded under copyright was 7 years with a renewal term of 7 years. At some point, and I don't remember, in the middle of the 19th century, the 1800s somewhere, that was extended and doubled to 14 plus 14 years. Then in 1909, the 1909 Copyright Act, which we still have to think about today, granted copyright protection for 28 years, an initial term of 28 years, and then you could renew it for a second 28-year term. So that added up to 56 years. Well, in the 1960s, the Congress started working on an updated copyright law, and what eventually became the Copyright Act of 1976, which instituted a different system. Rather than a fixed number of years, it said we're going to tie the ownership of the copyright to the life of the author and give an extra 70 years after the death of that author. So life plus, actually, sorry, it was life plus 50 years. That has since been extended. I'll get to that in a minute. But in the course of doing that, they realized that there were all these existing copyrights out there that were going to either expire right away or early in those new copyright laws and things like that. And so they decided to give it an extra 19 years of protection to take it out to 75 years total. And that was lining up with works that were created by companies, had 75 years of protection at that time, I believe. Works made for hire, things like that. Then in 1976, the new act took effect on January 1st, 1978, and the new law became life plus 70 for any works created after January 1st, 1978. Life plus 50, excuse me. The reason I keep making that mistake is that in 2000 or 2001, maybe it was 1999, but there was a new Copyright Extension Act that passed that added 20 years to all different copyright terms. So what had been life plus 50 became life plus 70. What had been 75 years, one is extended out to 95 years, and that's an operative date, why we have to think about the 1909 Act still. And a couple of other things were extended out as far as 125 years. So very sort of specific circumstances. So the current rule is, generally speaking, life of the author plus 70 years. But if the work was created prior to January of 1978, then the term is 95 years. So we have to count back. And that's why Sherlock Holmes is in the public domain, because it was written in the 1920s. Here we are, I'm sorry, in the 19-teens, I guess, in the 1920s. So here we are now into 2025. Anything written prior to 1930 is in the public domain under U.S. copyright law. And each January 1st that year steps forward. So starting next year, anything written prior to 1931 will be in the public domain and free to use. And so lots of works are falling into the public domain each year on January 1st. And that was just a way of simplifying things, to just say, we're not going to worry about the publication date or whatever, or the death date of the author. We're just going with January 1st of the year in which this happens. So if you're interested, you can go to, the Copyright Office has a public domain page. I think there's also a page at publicdomain.org that will tell you all the work. You can search it for a work to find out if it's in the public domain. I don't know that I would rely 100% on that, but it's a great starting point to get a sense of what's what. And each year there's we call it Public Domain Day, January 1st. And there are big announcements and articles about all the new works that have fallen into the public domain as of January 1st. And anyway, so that's that. So I hope that answers your question. The operative thing is 95 years. There was a sort of abortive attempt to extend it further a year or two ago, but it didn't happen, and Mickey Mouse is now in the public domain. It was 1925, I guess. No, 1931, I guess. I don't know, 1930, I guess, is when Steamboat Willie came out, something like that. So he's in the public domain now. Sherlock is in the public domain. Winnie the Pooh is in the public domain, and lots of others. So hope that helps. So let me see. Do I have any other questions to give answers for? I've exhausted all the ones that I've received in email in the last couple of weeks. If you would like to email me questions for my Asked and Answered series on YouTube, you can go over to firemark.com/questions. And I'm accumulate them, and then I'll make a few videos at a time. So yeah, that'd be my pleasure to answer that. And if there's any other questions in the chat, I'd love to do that as well. I'm going to stay on for another 5 minutes or so, and then call it a day on this Ask Me Anything session. Kind of having fun doing this, and I thank you all for the super chats. Really do appreciate that. It was unexpected, but I'm grateful. Thank you for that. And let me see, did I get everybody's questions? think I did. I think I got it. So I do appreciate you all. Thank you for being here with me. Let me see, do I have any other? Got the using pseudonyms. Should I form an LLC? Let me expand on the LLC question a little bit in case anybody else has questions and wants to get in there. But while you do that, I will quickly answer a little more about this. So an LLC, a limited liability company, is a business entity that is a separate person in the eyes of the law. So we usually recommend when you're starting a business that you consider forming either an LLC or corporation, because that separate person becomes the party that is liable if there's a problem, if there's a claim of some sort. Somebody slips and falls on the premises, or there's a copyright infringement or something like that. They first look to the company, which is the author of the copyright in a film situation or something. So we generally do recommend forming those. And the reason that LLCs are beneficial is that they shield you from liability. They shield the owners, the members of the limited liability company, from the liability. They provide certain tax advantages. There are things that a company can charge off against taxes, write off against taxes, that an individual cannot. It can become the employer for people who work for the business, and that can be valuable. Again, separation and avoidance of liability. It can also be used as a financing vehicle. So we often recommend with films, if you're raising money with investors, having an LLC is a great way to sell pieces of the LLC to the members. That's a securities transaction, so it's a complicated thing, but it's a way to sell off bits of ownership of the film project, and in exchange for the money that you're going to use to actually make the film. Now, that's why we recommend that each film be its own LLC. And we call these single-purpose entities, or single-purpose vehicle is another way we refer to them. And these single-purpose entities, then each film is its own, and then a company that makes multiple films would own several LLCs. And you can stack them. They can be nested, and one can own another, and things like that. They also provide a kind of street cred, I guess you could say. People sometimes feel more comfortable dealing with a business than with an individual, especially when there's lots of money at stake. So that's another valid reason for doing it. But you got to do it before you make the film, before you get too far down the road, because otherwise, the people who invested or contributed money, they contributed to the individual, and then the person transfers it into the LLC, and then something happened in the way the film was made. Well, the LLC doesn't want to be held responsible, and often can't be, because there's no assets there other than the film. So the party that's suing goes after the individuals anyway, and you may not be able to use the shield. So it's important to think about these things early on in the process, and do things right. And that's why consulting an entertainment lawyer really is important. So hope that helps. I don't see any other questions coming in the chat. So I think I will call it a day, signing off here. I appreciate those who came in, who commented, who questioned, who super chatted me. And I think I'll come back and do this again in a few weeks. So keep an eye out, stay tuned, and I'll look forward to answering more questions. Save them up or send them in, and I'll get it. It's firemark.com/questions is where you want to send them. And I'll look forward to speaking to all of you again. Thank you for joining me, especially you, Jake from Windy City, Movie Maniacs, Certain Exposures, Felina. Did I get your last name? Felina Carter. I think I got everybody. So thank you all for being here with me, and I'll see you again real soon.